All righty. Again, welcome. Good afternoon, everybody. It's so good to see you all, at least virtually. We're going to start here with some Zoom reminders. So just saying, if you're calling in, just a reminder to please mute your phone. If you don't have a dedicated mute button, pressing *6 should work. And if you're using your computer audio, all participants have been muted. During the Q&A session, you will have a chance to unmute and ask a question, and you can also enter your questions in the chat. I'll be monitoring that to make sure it's all good to go. And lastly, given that session is being recorded, we will add this recording, the chat, and all of the amazing resources shared here today, the slides, everything on our Learning Network website, so that way you can access it after our conversation today. And we invite those of you who are able to access the chat on Zoom to introduce yourself and to share one of your favorite activities to do with youth. My name is Megan Pitas. I was born and raised on Piscataway land, and I currently live and work on Dunedin Eshena. And for my sister and I, one of my favorite activities to do is having coffee and being silly in the mornings. And that little doot noise that you just heard is somebody joining by phone. Hello, welcome. You'll probably hear a couple more of those as people get settled here today. Oh, sorry, go ahead. All right. And with that, as we begin this afternoon, I'd like to acknowledge that everywhere we work and live is Indigenous land. I live and work on Dunedin Eshena, as we have an Alaska Climate Adaptation Science Center office here on the Alaska Pacific University campus, as well as our team is located all around the state with team members on Tlinkit-Ani and Quinhagak, as well as another office on the traditional territory of the Lower Tanana Dene people on the Trothuda campus. Trothuda was given its name by traditional chief Peter John, pictured here in the blue hat, from Minto, who shared that this was a place for people to come from all around to dig for potatoes, share, hunt for caribou. The story was shared in 1990, and its official name was changed in 2013. And we also wanted to share a little bit more information about us and the Tribal Resilience Learning Network. We are a network of support with a variety of expertise and assistance and opportunities available, a bunch of which is listed here. We really aim to have a flexible team approach to providing support, as we each have different backgrounds and places and roles where we're asked to show up. So the majority of our tribal liaisons in particular this week are at a week-long symposium on co-stewardship. Otherwise, you'd also be hearing from the remainder of our team that's working in this sphere as well, particularly our amazing and incredible Indigenous liaisons. We really aim to ground everything in Indigenous perspectives and experiences, and wanted you to hear from Indigenous youth voices today. We also want to recognize that our youth are asked to show up in so many places, and given some of their limited availability, you'll be hearing a few recorded videos from Indigenous youth in Alaska and beyond. And really quickly, I just wanted to highlight a couple of youth experiences that have some upcoming deadlines that I think a lot of you all and the youth that you work with will be interested in. The first of which is the Native Youth Climate Adaptation Leadership Congress, or NICALC, and Inspiring Girls Expeditions Alaska. Both are completely tuition-free and great for students and youth looking to get more involved in leadership, science, outdoor skills, the whole gambit. There's travel assistance and funding available for both. And those are two projects that our team is pretty knowledgeable about. So if you have any questions, please shoot us an email. I'll put my contact information in the chat for all of this as well. And lastly, the Native American Fish and Wildlife Society also has a huge variety of youth opportunities and resources available on their website as well. From summer youth practicums to internships nationally and regionally to other professional development webinars, there's a whole bunch out there, as I know you all are all aware. But just as a reminder, there's a couple of these here as well. And again, I can answer questions on any of this. Just shoot me an email. And with that, we would like to welcome our speaker today, Mr. Andrew Welle. Andrew Welle is a senior staff attorney with Our Children's Trust, the world's only nonprofit public interest research law firm, dedicated exclusively to securing the legal right to a safe climate for youth and future generations. Andrew works on legal actions in both the federal and state court systems, including Juliana versus the United States and Genesis B versus US EPA, and serves as lead counsel in Segunik versus the state of Alaska and Natalie R versus state of Utah. In his free time, Andrew enjoys fishing, backpacking, trail running, exploring the Pacific Northwest, and playing in the local band, the Garden Weasels. Welcome, Andrew. I will hand it off to you.
Great. Thank you very much for the introduction, for the warm welcome and the invitation, Megan. It's really a pleasure to be here. And thank you everyone for joining us today. As Megan mentioned, my name is Andrew Welle. I'm a senior staff attorney at Our Children's Trust, and I'm calling in from from Eugene, Oregon, where Our Children's Trust is headquartered. We are on the Kalapuya Alihi, which is the traditional homelands of the Kalapuya people. So just give me a moment here and I will start sharing my screen for the presentation today. Let's see. Okay, is that coming through? Great. Okay, well, again, thank you everyone for being here today. Today, I'd like to tell you a little bit about the work that we do here at Our Children's Trust. As Megan mentioned, we are a nonprofit law firm, and we're really dedicated to one thing, and that's securing climate justice for youth and future generations in court systems across our country and across the world. So today I'd like to highlight that work, and I'd like to highlight the work that we're doing as that's reflected in a number of our cases, also including the work that we've been doing in Alaska's court system since 2010. And I'd also like to highlight the voices and the experiences of our youth plaintiffs and experts from Indigenous communities and why those perspectives and voices and knowledge are critical to the work that we're doing into securing climate justice in our court system. So to tell you a bit about Our Children's Trust, as I mentioned, we are a nonprofit law firm dedicated to securing climate justice for youth across the world. And all of our work is really based on three foundational principles. So the first is that all of our clients in our legal actions are youth. We advocate for and elevate the voices of diverse youth and future generations for climate rights in our court systems. The second pillar that underlies our work is that all of our work is underlined by the best available climate science. So we work with the world's leading climate experts and other scientific experts to make sure that the remedies that we are seeking in court are aligned with what the science tells us is necessary to stabilize the climate system and preserve a safe world for children and future generations. And the third principle underlying all of our work is that all of it is based in pursuit of the recognition and securement of fundamental human rights, whether those are reflected in constitutions or other instruments. So Our Children's Trust has been doing this work since 2010. We're the only law firm on the planet that's exclusively dedicated to representing children and youth to protect the right to a secure climate system. And we have been seeing significant momentum building over the past 14 years, culminating in what we're really seeing now as a turning tide with historic wins starting to come in, where you may have heard the news about our landmark victory for youth in Montana in the summer of 2023, which was the first constitutional climate case to go to trial. And that culminated in a amazing landmark victory for the youth that we represent, which we are now bringing to the Montana Supreme Court to uphold that victory. We'll talk about that in a little bit more here. So in addition to that case, we have cases that we support all over the world, and three of those are currently on track for trials in 2024 and 2025. And significantly for Alaska, we will be filing a new youth-led case early this year, and we'll tell you a bit more about that and the opportunity for youth to be involved later in this presentation. So as I mentioned, we support youth all over the world in securing the right to a stable climate system. Much of our work is focused on North America because we are headquartered here. So we have two suits against the federal government in which we represent youth. One is Juliana versus United States, which I'll be discussing a bit more length shortly here. Another is Genesis B versus United States EPA, which we just filed last month on behalf of a group of youth from California. We also have pending litigation in a number of states across the country. So as I mentioned, our landmark victory in the state of Montana. We also have active litigation in Virginia, in Utah, and a case against the Hawaii Department of Transportation, which will be going to trial in June of this year. We also support youth all over the world in foreign jurisdictions. So for instance, we recently secured a positive ruling for youth in our Canada case that greenlights that case for trial, which we anticipate in late 2024, maybe early 2025. Also litigation in Mexico, India, and other areas across the world. So to highlight one of these cases, I'll be discussing more, but we'll start with Juliana versus United States. This is emblematic of a lot of the work that we do. So starting out with Juliana, I think makes sense. So this case is 21 youth from across the entire United States, from Alaska to Florida, including plaintiff in the middle here, Nathan Bering. You'll see the tall young man in the blue shirt with the beard is from Fairbanks, Alaska, and was actually presented at a previous info session for the Tribal Resilience Learning Network. We're proud to have him on the case. All of these youth, as I mentioned, are from across the United States. They're experiencing climate change in different ways, impacts to their health and safety, their cultural and spiritual traditions and communities. And the gist of the case essentially is that the federal government has known of the dangers of climate change and the science behind climate change for decades at the highest levels of the executive branches. And in the face of that knowledge, rather than transitioning our national energy system off of fossil fuels, has really doubled down in their control of fossil fuel permitting, of infrastructure, and other control of our national fossil fuel energy system in a way that has perpetuated and actively caused the climate crisis. And the case alleges that by actively contributing to the climate crisis by maintaining the fossil fuel energy system, the United States government is responsible for nearly a quarter of cumulative greenhouse gas emissions across the globe, and is directly causing the endangerment of the lives and the health and safety and cultural traditions of the young people who have brought this case in violation of their rights under the federal constitution. So what do those injuries look like? Well, this case was filed in 2017, and it has been winding its way, 2015, and has been winding its way through the federal court system since then, with multiple trips up to the Supreme Court and back down to the district court in Oregon. And so we have a robust record and findings and conclusions of law along the length of that litigation to where we've been so far that are very favorable to the plaintiffs. So in one aspect of that is recognition of the injuries that the youth in this case, in Juliana versus United States, where I think are representative of how youth are harmed across the country by climate change. So the court system in Juliana has recognized the exacerbated medical conditions of young people resulting from climate change, damage to their property, psychological harm, and harms to their cultural and spiritual traditions and communities. And the Ninth Circuit, and the quote that you'll see here, has recognized that those injuries are real and that they impart standing to these youth who are harmed to bring constitutional claims against their government for causing climate change, causing their injuries in violation of their rights. So to touch on the importance of Indigenous youth and perspectives in constitutional climate litigation, we can highlight the experience of one of the plaintiffs in Juliana, Jamie Butler here. Jamie is Diné, and she grew up on the Navajo Nation Reservation in Cameron, Arizona. And the climate impacts that she is experiencing there are very serious, and actually have resulted in her having to relocate off of the Navajo reservation because of water scarcity issues. So separating her from her family and from her community there. And as you can see here in some of the further summaries of the ways that she's being impacted, Jamie has a deep worry that the rest of her extended family will be forced to leave the reservation and displaced from their land, which will further erode her culture and way of life. And there's a quote here from her that says, "Participating in sacred Navajo ceremonies on the reservation is an important part of her life, and that climate impacts are starting to harm the ability for her and her tribe to participate in their traditional ceremonies." So importantly, the Ninth Circuit Court of Appeals in Juliana has recognized that these impacts to Jamie, to her cultural traditions, and to the tribe give her standing to bring constitutional claims against the United States government for violating her constitutional rights. So the Ninth Circuit in the court system in Juliana has recognized that these young people are being harmed by climate change. They've also recognized that the federal government's contributions to the climate crisis through permitting fossil fuels, permitting infrastructure, leasing federal lands for fossil fuel development are causing and contributing to those injuries, which also gives these young people standing, allows them to bring these constitutional claims against their government for enforcement of their constitutional rights and to stop the government from actively continuing to contribute to the climate crisis and to reduce emissions that will help to preserve their futures. So the Ninth Circuit here in this quote recognized that a substantial evidentiary record documents that the federal government has not only long promoted fossil fuels, but also has long known of the consequences of that, and that shows the causation of the climate crisis contributions of the federal government to the injuries that these young people are experiencing, including Jamie, as we've seen in the last slide. So the court system has acknowledged and recognized that not only the federal government is causing these injuries, but that it's harming these young people. So how does that relate to the claims that are being brought in this case and others like it, like Juliana? The theory of this case is that by causing these harms to the young people, endangering their health and safety, reducing their lifespans, endangering the existence and continuity of their communities and cultures, that is violating their right to life, their liberty, their personal security. It's discriminating against them as children with respect to their rights to preservation of the world and the natural resources that are necessary for their health and safety, and that it violates the government's public trust responsibilities to manage crucial natural resources necessary for life for their benefit. And the court system in Juliana has recognized that those are valid constitutional claims. So here is a quote from U.S. District Court Judge Ann Aiken, who's presiding over Juliana, where she has recognized that when a young person alleges that the government's affirmative actions are substantially damaging the climate system in a way that will cause human deaths, shorten lifespans, result in widespread damage to property, threaten food sources, and dramatically alter the planet's ecosystem, that states a valid constitutional claim. And Judge Aiken summarized that by saying that the right to a climate system capable of sustaining human life is a fundamental right under the federal Constitution. And the courts in Juliana have also recognized that providing a remedy is within the power of courts in these types of cases in Juliana, and which is transferable to constitutional climate change litigation across the country and across the world. Recognition that where courts are able to step in and declare that government policy that affirmatively contributes to the climate crisis should be declared unconstitutional and should not be allowed to be implemented, that will reduce emissions, prevent the worsening of the climate crisis, and provide real relief to youth and future generations who are suffering harms from climate change. So that's a lot of powerful recognition of the rights of children and advancing the case of Juliana forward towards trial. So you might be asking, what's next? Well, on December 29th of this year, Judge Ann Aiken came out with another very powerful opinion, greenlighting the Juliana case for trial after 8 years of winding its way through the court system. So we are hopeful and anticipating a trial date in Juliana later this year or early in 2025. So moving on, I'd like to highlight another of our Children's Trust cases, and one that you may have heard about in the news last summer. That's Held v. State of Montana, which is the first constitutional climate case to go to trial in the United States. And as I mentioned, resulted in a very favorable ruling for the young people that we represent in Montana. So like all of our cases, Held v. State of Montana is a coalition of youth from across their jurisdiction suing their government. So you'll see here the youth who are involved in Held v. Montana and where they're at, where they come from in the map of the state of Montana. Montana is similar to Juliana in many of the constitutional climate litigation cases that Our Children's Trust supports, insofar as it is challenging the state's affirmative contributions to the climate crisis. And in Held, what that looks like is challenging specific state laws, in particular, what's called the climate exception to the state's Montana Environmental Policy Act, under which the state was forbidden to consider the greenhouse gas emissions and climate effects of their permitting decisions in authorizing pipelines and fossil fuel development and their statutory policy of promoting fossil fuels. So the youth in the case challenged those laws as directing the government, requiring them to promote and affirmatively authorize fossil fuel development activities that are thereby contributing to the climate crisis and the harms that the young people were experiencing in that case. And the claims were that these laws, by directing the state to worsen the climate crisis, are violating the constitutional right of the young plaintiffs to a clean and healthy environment, to their individual dignity and equal protection, and their health, safety, life, and liberty. So as I mentioned, this was the first constitutional climate case to go to trial in the United States. It was a long road to getting to this first trial, and now that it's happened, we feel like the momentum is really building. And as I mentioned, many of these other cases are going to trial in the United States as well. And you can see synchronicity between the courts and the persuasive authority of really important decisions like Held v. Montana being instrumental in other jurisdictions and in new cases that are filed in other states as well. So here you see some pictures of the youth plaintiffs in Montana testifying, getting to tell their story in a courtroom and enter evidence to say, this is how I am being impacted by climate change, and this is what I have at stake from the government's policy of actively contributing to the climate crisis. So to highlight another one of the individual plaintiffs, and again, stress the importance of Indigenous voices and experiences, particularly of youth in constitutional climate litigation. Here you'll see our plaintiff Serial S, who is a member of the Confederated Salish and Kootenai tribes, and Serial lives on the Flathead Indian Reservation. And some of the harms and experiences that she brought to bear in this case are how the climate crisis threatens her right to learn her traditional, cultural, and spiritual practices, and her ability to transmit those on to future generations so that her culture can continue in perpetuity as it has for generations past. So in particular, Serial testified and brought evidence that progressively decreasing snowfall as a result of the climate crisis is affecting, in particular, the annual telling of the coyote and creation stories of her tribe, which can only be told when snow is on the ground. And that the climate crisis disrupts winter snowpack in her area and in her communities, creating low water levels, which impact her ability to fish bull and rainbow trout and participate in subsistence activities. And that it otherwise affects wild game like bison, which are also central parts of her culture and a critical food source for her and her community. And she also testified on how the huckleberry picking season is later in the year. So many impacts to her ability to provide for her food security and for the ability for her to learn, practice, and transmit her cultural traditions. So also, one of the major aspects of trial was the testimony of expert witnesses on behalf of the youth plaintiffs. So experts not only in climate science, but also on the Montana Constitution, on greenhouse gas calculations and accounting, on the economic effects of continued promotion of fossil fuels and the climate crisis, and again, critically for the importance of these cases on the impacts to Native communities. So up in the right-hand corner in this picture, and as featured in the next picture, you will see the expert Michael Durglow, also known as Standing Grizzly Bear, who testified in this case. And Michael is the head of the Confederated Salish and Kootenai tribes of the Flathead Indian Reservation's Tribal Preservation Chairman on the climate, with lots of climate expertise on how the tribes are being affected. And he testified on the spiritual, traditional, aspects of the importance of the natural environment and resources and how climate change threatens those traditional resources and the values of the tribes, and in particular youth, and testified on how the government's continuing contributions to the climate crisis impact various aspects of tribal life and values. So after trial, it was a number of months, but fairly quickly afterwards, in August, Judge Seeley, the presiding judge in the case, came out with her final decision on the youth's claims. And it was overwhelmingly in the youth's favor. So what we would describe as a landmark victory for constitutional justice on behalf of these Montana plaintiffs. Michael Gerard, quote, as it featured here, Michael Gerard is the director of the Columbia Law School's Sabin Center for Climate Change. And he described the case as the single strongest decision on climate change ever issued by a court. So what did the court decide? Well, we'll feature a number of the really important aspects of the case, and all of which I think are going to be instrumental and very important in other constitutional climate litigation in other states, including future legal actions in Alaska. So first, Judge Seeley recognized that the plaintiffs in the case have proven that they are injured by climate change. And not only that, but that every additional ton of greenhouse gas emissions, so not just overwhelmingly large, huge emissions of climate change that are coming from entire countries, but individual tons of greenhouse gases are important and contribute to the plaintiff's injuries and risk locking in irreversible climate injuries. So not only did she say, the state of Montana's emissions as a whole are endangering the young plaintiffs, but that we are in such a dire position with respect to the climate crisis that we are at a point where every additional ton of greenhouse gas emissions matters. Judge Seeley recognized that Montana's greenhouse gas contributions are a significant factor in causing the climate injuries of the young plaintiffs who are involved in the case. And again, this is instrumental not only for this case, but for constitutional climate litigation as a whole going forward in other jurisdictions as well, including in Alaska. And Judge Seeley also recognized that declaring the laws that direct the state to promote oil and gas development unconstitutional would reduce Montana's emissions, and it would reduce the climate harms that the youth plaintiffs would otherwise face. And so that a favorable ruling from a judge or from the court system makes a huge difference for these young people in terms of the world that they will inherit and the climate impacts that they will face in the future. And crucially, Judge Seeley found that the state's policies that direct the state to contribute to the climate crisis by promoting oil and gas are unconstitutional, that they violate the constitutional rights of these young people to a clean and healthful environment, that they violate their rights to life, to equal protection, to their health and safety, and not only the right to a clean and healthful environment, which is unique to Montana's constitution and a handful of constitutions across the country, but also these recognized and established constitutional rights to life, health, and safety that are present not only in Montana's constitution, but in every constitution across the United States and in the federal constitution as well. But this was a ruling based on the Montana Constitution. And Judge Seeley also issued relief in the plaintiff's favor. So not only did she declare these laws unconstitutional, but she issued a ruling that prohibits the state from continuing to carry out the law that she found unconstitutional, which will have a very real effect in terms of the way that the state of Montana is required to make decisions respecting whether oil and gas development can go forward. And this will have a major effect on the state's emissions going forward. Okay, so that's it for Help v. Montana. If folks have questions about that, I'm happy to answer those after the presentation. But I wanted to also quickly highlight before we start talking about the history of OCT's legal actions in Alaska and opportunities going forward, to highlight one more case, which is our children's trust litigation in Hawaii. The case is called Navahine versus Hawaii Department of Transportation. And here in this picture, we'll see 8 of the 14 youth plaintiffs involved. So the case is focused on Hawaii's Department of Transportation's operation of a transportation system that is perpetuating the climate crisis by perpetuating the use of internal combustion engines and locking in emissions from the transportation system. The claims in the case are grounded in the state constitution's right to a clean and helpful environment, and also their protections of the public trust doctrine, which again hold that the government is tasked with managing crucial natural resources for the benefit of present and future generations, and needs to manage those sustainably. And the public trust doctrine in Hawaii is constitutionalized just as it is in Alaska. So the case features 14 young plaintiffs. The vast majority of them are Native Hawaiian, and large portions of the complaint that detail their allegations and the ways that they are being harmed by the state's maintenance and perpetuation of a fossil fuel transportation system are in the Native Hawaiian language. As I mentioned, this case is also moving swiftly towards trial. We've secured a number of favorable decisions that have greenlit this case towards trial and recognized the standing of the youth plaintiffs, that their claims are proper for judicial review, and that scheduling trial for June of 2024. And building on existing Hawaii law, much of which was influenced by work that Our Children's Trust has done and scholarship that we've published. So for instance, Chief Justice Mike Wilson in the case of In re Halco recognized that the right to a life-sustaining climate system is included in the due process rights to life, liberty, and property. So continuing with highlighting the importance of Indigenous youth and their experiences in these claims, and in presenting evidence to the courts of how youth are being harmed by climate policies and energy policies that are challenging these cases. You'll see here the young plaintiff Kaliko from the Hawaii case. She's actually the youngest plaintiff in the case. Kaliko is Native Hawaiian, and she has experienced some really just devastating impacts. And sharing her story with the court and with the world has been really eye-opening, I think, and one of the reasons why this case has been successful in moving towards trial. So, for instance, Kaliko is experiencing really devastating impacts to her access to water in Hawaii, in Maui, that threatens her ability to grow subsistence crops. And tragically, she's actually lost 2 homes to extreme events related to climate change. So her first home was lost to intense flooding during a tropical storm that was the first to make landfall on Maui ever, and was forced to relocate to Lahaina, and then tragically and devastatingly lost that home to the recent wildfires in Lahaina that were driven by climate-related conditions. Kaliko was recently featured actually on Here and Now, and I'm sorry I don't have a link to that, but if you Google Kaliko Here and Now or Navahine v. Hawaii, you can find a really powerful interview with her. Okay, so those are 3 cases among many that Our Children's Trust supports outside of Alaska, but we've also been doing work in Alaska since 2010. And we've litigated 2 cases so far with some very important results that we're going to be building on in the next case we'll be filing. So here in this picture, you see Nelson Canuck, who was the lead plaintiff in the first case that Our Children's Trust supported in Alaska, which was called Canuck versus State of Alaska. Nelson is Yupik, and he's from Kipnik. And the case also featured Ananda, who's Ayak Athabaskan, from Anchorage with traditional homelands in Cordova. So this case was very similar to the first wave of litigation that Our Children's Trust brought all across the country. Nelson and his co-plaintiffs brought claims challenging the state of Alaska's failure to address greenhouse gas emissions. And essentially they were saying the state is not doing enough to protect us from climate change, not doing enough to reduce Alaska's emissions. And that is a violation of the public trust doctrine under Article 8 of Alaska's Constitution, which requires the state to protect the natural resources that Nelson, children, and future generations rely on for subsistence, and for many of the other important reasons that folks in Alaska rely on natural resources for their health and safety, their food security, their need to breathe clean air and have access to clean water. And we have a video here that it's always best to allow youth to tell their own stories in their own words, which is what we strive to do in the complaints, and then certainly and getting these cases towards trial so that the youth can take the stand and give testimony on what they're experiencing and the importance of these claims to their lives and their communities. So I will press play on this, which features Nelson explaining what climate change means to him and the harms that he was facing in Kipnuk in terms of erosion of the land of his community and impacts to his subsistence and traditional cultural values.
Lower temperatures are causing the permafrost to melt, and the permafrost to melt affects the land due to erosion. So the erosion cuts off some land that falls into the river, and we lose quite a bit each year. And we have another 40 or so feet left until the river reaches our house. If it keeps moving at the same rate, then in the next few years, then we might have to move a house to another location. It does scare me because we don't know if there'll be an ice pack or not in the future. But if there's not, then it would be much harder to harvest seal for our subsistence way of lifestyle, especially for the seal oil that we heavily depend on in this part of our everyday lives. The warmer temperatures could affect our way of life out here. And if we didn't get to come out here and do any of this with picking berries or any of that, it would be hard on our family, and not only my family, but all of the families in the community as well, because about 90% or so of our diet year round is from the tundra or the ocean. And it will be hard economically. Yeah, we're really dependent on all this food that we get, and I'm very thankful for it. We're a small town that probably no one knows about, but I like to have our voices heard and letting other people know how much we are affected by climate change. I'm asking for help with how we're going to deal with this. My name is Nelson Kanak, and I'm 16 years old. My name in the Yupik language is Angusak, and it means strong, wise.
So this case was filed on behalf of Nelson and his co-plaintiffs in 2010 or 2011, I'm sorry, and it eventually reached the Alaska Supreme Court, and they issued a decision in 2014. And although the case was not ultimately successful in terms of securing a ruling recognizing Nelson and his co-plaintiffs' constitutional rights, like we saw recently in Montana, importantly, it did secure a number of very favorable and important rulings that we have built on in subsequent cases in Alaska, and that are going to be critical to us moving forward in the new case that we're developing, that we have strong hopes will afford us an opportunity to secure a ruling like we did in Montana recently. So, what did that look like in terms of what did the courts say in Nelson's case? Well, one of the most important things that they recognized was that Nelson and Alaska youth like him are experiencing the impacts of climate change in real and tangible ways that give them standing to bring suits against the state over their policies with respect to climate change. So the Alaska Supreme Court noted that the erosion, flooding, increased temperatures, and the threats to Nelson's home, his village, his cultural traditions and subsistence are real and important injuries that allow him and other youth experiencing the effects of climate change to bring the types of lawsuits that he did, challenging the state's contributions or the state's conduct with respect to climate change and energy policy. The state Supreme Court also recognized that the impacts that Ananda was facing and that her community in Cordova was facing to wild copper river salmon and other food sources also gave her standing. So ultimately, though, the court ruled that in the context of the claims that said the state is not doing enough to address climate change, these failure to act claims, that the court would not step in to tell the state exactly what it needed to do to reduce emissions. But it did give some indications of what a case that they might decide would look like. They said it's not their job to decide, quote unquote, in the first instance, what the state's energy policy should be. So in the wake of that decision, our Children's Trust, on behalf of a group of Alaska youth from all across the state, 16 of them, went back to the drawing board, and we brought another case that said, this case is not about the state of Alaska not doing enough to address climate change. The state of Alaska, its government, is affirmatively contributing to the climate crisis, and it has an explicit policy of promoting oil and gas development, and through that is affirmatively causing and contributing to the climate crisis and the types of impacts that youth across the state are experiencing. So here in this picture, you'll see a number of the young plaintiffs that were involved in the case at oral argument before the Alaska Supreme Court in 2019. The case is called Segunik v. State, named after Summer Segunik, who is the young woman in the middle of the picture with the purple shirt on. Summer is a Nup'ik from the native village of Unalakleet. The case also featured Lexine, who's Gwich'in from Fort Yukon, and again, Ananda, who's Ayak Athabaskan with homelands in Cordova, and also Vanessa, who's of the Rocky Boy tribe from Montana. So highlighting the experiences of some of the Alaska Native youth involved in the case. As I mentioned, Lexine is Gwich'in from Fort Yukon, and many of the harms that she's experiencing are related to her people's reliance on caribou as a subsistence food source and important aspect of their cultural traditions. Ananda, who was a participant in the Canuck case as well, was a member of this case as well. As mentioned, she's Ayak Athabaskan with homelands in Cordova, and some of the impacts that she brought to bear in the case were her ability to engage in activities with her sled dogs and to continue that on as a tradition, as well as impacts to salmon and subsistence resources that are important for her community. And the lead plaintiff, Summer, here, who you'll see pictured with her quote about why one of the reasons that she was involved in the case and how she was being impacted by climate change and her subsistence activities and cultural activities. Summer would have loved to have been here to speak with you directly today, but had a conflict with her work. But she did partner with us in a previous presentation to the National Association of Women Judges, and I do have some video of her. And again, I think it's best to kind of let the youth explain in their own words how they're experiencing the climate crisis and why they're interested in participating in these suits. So I will feature that video of Summer here.
Good morning or good afternoon. I'm a Nup'ik, so my name is Summer Segunik and I'm 21 years old. I was born and raised in Alaska, and I was given the Nup'ik names of Abusanuk, Masu, and Ikubuk. I reside in the native village of Unalakleet, and I have 7 immediate family members living here, 5 being female. Through my family, I started practicing our traditional ways when I was only 1 year old. I learned everything that I know from my mother, my 2 aunties, and my grandmother. Never indoors, I would follow my aunties to their traps, first learning how to differentiate between different animal tracks and prints. Excuse me. My family has taught me the importance of our values, customs, and lifestyle. We are taught not only in school about our history, but we are shown what it means to be Nup'ik by our family, friends, and members of the community. Being a Nup'ik means that we cherish these memories that we create together as a community and family, practicing traditions such as skin sewing, hunting, fishing, and harvesting our plants, roots, and berries. My ancestors have inhabited the area for the past 2,200 years, passing down the valuable knowledge that we use today. In my community, we have the highest respect for our elders because without them, we would have no culture. It takes a community to raise a child, teaching each other what it means to be Indigenous, Alaska Native, or Nup'ik. The climate crisis is impacting my traditions right now. Today, we are losing this knowledge that passed down generation by generation.
Thank you. And can you tell me some of the harms that you and your community are seeing?
Climate change has greatly affected our lifestyle, harming our community, our cultural traditions, our subsistence, and our heritage. A large part of our diet is provided by the land and ocean that surrounds and protects us. But over my 21 years of life, I've noticed that our lifestyle is being threatened by the warming of our climate. I strongly believe that climate change will make it nearly impossible to practice our hunting and gathering. Due to the loss of sea ice, the melting of permafrost, and the erosion of our land, it has become extremely dangerous for our community to travel to harvest our food. When I was born, caribou would roam like on the tundra really close to our community, but now we have to travel about 200 to 300 miles just to catch them. This difficulty threatens our food security, our transportation, and our hope for a safe and promising future. Good morning or good afternoon.
Excuse me. Okay, so this case, Summers case, along with her co-plaintiffs, went all the way up again to the Alaska Supreme Court. And in January of 2022, the Supreme Court issued their decision, which was a narrowly split 3-2 decision. So ultimately, although the Supreme Court didn't allow the case to go to trial, again, we won some really critical wins on a number of different issues that are going to be really instrumental in moving legal litigation to secure the right to a stable climate system under Alaska's Constitution forward. So one of those things that was very important was the dissenting and concurring opinion of Justices Mawson and Carney. They were the only two members of the court and only two members of the Alaska Supreme Court so far who have addressed the question of whether Alaska's Constitution includes a fundamental right to a livable climate system. And they said emphatically, yes, it does. And it's protected under Article 8 of Alaska's Constitution. So we'll be able to use this recognition going forward to build new cases. And critically, although the majority did not allow the case to move forward to trial and essentially said, declaring the state's energy policy of promoting fossil fuels, they questioned what type of relief that would provide and said, if you present us with a more immediate and specific controversy, that will allow us to decide whether Alaska's Constitution protects these fundamental rights of these young people. And again, the concurring justices said, yes, it does, which is a strong building block for us to go forward. And the majority opinion explicitly said that the Alaska Constitution doesn't leave the plaintiffs without recourse. So between the dissenting opinion and the majority, there's a strong indication and what I would characterize almost as a blueprint of how to move forward with constitutional climate litigation in Alaska. And we have been spending the last year or so in building that case, and we'll be filing it early next year. We think building on the momentum of the Montana decision and on the previous litigation in Alaska, that this new case that we will be filing stands a very, very strong chance of going to trial and securing the right to a livable climate system for youth in Alaska under Alaska's Constitution. And that the things that we will be challenging in this case, which are activities that the state is engaging in presently that will drastically increase Alaska's greenhouse gas emissions, that a favorable win in this case would not only prevent those emissions from going forward, but having the recognition of a stable climate system, right to a stable climate system, will fundamentally change things going forward with respect to the way that the Alaska government is required to orient itself to oil and gas development. So we feel a lot of promising aspects of what's going to happen from this new case, and we're really excited to launch it in 2024. At this point, the case is open to youth from across the state of Alaska, from all different types of socioeconomic, geographic, cultural backgrounds. We have been stressing the importance of Indigenous voices in this presentation, and we certainly welcome and encourage Indigenous youth who may be interested in joining this case and pursuing the right to a stable climate system under Alaska's Constitution to get in touch with us. And you'll see some ways to do that on this slide. But the case is also open to youth from other cultural and geographic backgrounds as well. So if you're interested in learning more about the case, I would encourage you to visit ourchildrenstrust.org/Alaska. You can also use the QR code that's featured on the screen right here. And with that, I will open things up to questions.
Yay, great. Thank you so much, Andrew. I know I really appreciate it. I feel really excited about, especially like the blueprint that you just kind of laid out there right at the end. I think it's particularly exciting to see. You're getting lots of little clapping hands emojis too. I guess just to start us off, I saw, Sharina, that you had a couple of questions that you put in the chat, and I am happy to read them aloud, but also wanted to give you a chance to come off mute if you're interested.
Hey, it's Rena. Yeah, I was just wondering if there's any tribal governance that's been offered to students like this, just because I feel like a lot of them are either Native American or Alaska Native, but like going to school for tribal governance is pretty cool. If there's a lot of good information, and I'm just wondering if that's like an option you guys help them with, or like, and the tribes down states, do they even have a village council or a tribal hall or employees that work for them? I know it's different down states than it is compared to Alaska, but I feel like if they had a good um tribal employees, like things would move a lot easier for them. I know it's different down states than it is here, so I don't know the whole, like, all of the information, but this is a lot. And I really like that the youth are getting more involved. So those were my questions.
Sure. Well, thanks, Sharina. I'm happy to speak to that. We don't have any formal programs to involve youth with tribal schools or tribal governance, but I will say that from our experience working with Native and Indigenous youth, that there are opportunities that informally present themselves as a result of participation in this litigation. So, for instance, opportunities and ways to be introduced to folks who are involved in tribal governance in tribal councils. So as I featured with Michael Durglow, who is one of the representatives and expert witnesses in Held v. Montana, I think that's emblematic of the potentiality of these kind of experiences, where through this litigation, we seek to make sure that we are connected with members of tribal governance who can speak to some of the issues that are involved in these communities and perhaps help us present evidence or expert testimony. And those relationships and that relationship building presents an opportunity for youth to get involved and to meet those folks and explore opportunities that might be available to them.
Cool, that's all I wanted to know. Thank you.
Great. Thank you both. And thank you, Sharina, for your good question. Do we have any other questions, I guess, that's come up in the course of our conversation? We probably have time for maybe one or two more. I'm doing my teacher 7-second pause, but hearing none, I guess also if people do have questions, where can they find you afterwards? Andrew, is there a way, should they just contact you through the form, contact you directly? What would you like people to do?
Sure. Yeah, folks are welcome to get in touch with me via email. My email address is on the presentation. I can also put it in the chat, and it is andrew@ourchildrenstrust.org. I would encourage folks who are interested to hear more about the Alaska case and the opportunity for youth who might be interested to hear more about the case to learn more about the opportunity to join. You can, again, find that at ourchildrenstrust.org/Alaska. And there are many links, not many, I should say, a few links on that page to learn more about the case, to learn more about what the process involved in being a plaintiff looks like and the requirements and commitments involved, which I would characterize as fairly moderate, a number of hours here and there over the course of litigation. And there's also a new client interest form for youth who would like to connect with us directly about the possibility of being involved in the case.
Great. Thank you so much. All right, with that, I'll probably just share one last contact slide too, and just a reminder that a couple of the opportunities we shared at the top of the session have due dates that are coming up, and this Inspiring Girls deadline, I think I saw Stephanie on the call, who I know is their DEI fellow this year. But that deadline is a little bit soft, so even if you get it in after the 31st, please do. And same with NICALC, those applications are due in March, and those are great opportunities, I think, for youth that can dip their toe into this work as well, especially when thinking about starting those conversations for climate change in their communities, kind of like all of the information that Andrew presented today. Here's our contact email as well, and a website where all of the past information sessions and where this information session recording will be posted, as well as the slides, all of the links, the chat, all of that kind of thing will be on our website within the next couple of days. And we just wanted to say a huge thank you to you all for joining today and for being so excited about youth and climate change litigation in Alaska. We really appreciate it and hope you have a great rest of your day.
Thanks, everyone.
Thanks, everybody.